This judgment was prepared by me, and I will deliver it. Well, this is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court in suit number CA/PEPC/05/2023, which was delivered on the 6th of September 2023. In the said judgment, the court below substantially sustained the respondent's objections to the petition, the petitioner's reply to the respondent's respective replies, the competence of witnesses subpoenaed by the petitioners, and the admissibility of several documents sought to be tendered by the appellants. After resolving all the issues in favor of the respondents, the lower court dismissed the petition for lacking merit. Dissatisfied with the dismissal of the petition, the appellants filed a notice of appeal on the 18th of September 2023. A brief facts of the case giving birth to this appeal are that election into the office of President of the Federal Republic of Nigeria was conducted by the Independent National Electoral Commission, INEC, on 25th February 2023, wherein the second and third respondents emerged winners with a total of 8,794,726 votes, while the appellants came second with 6,984,524 votes. 16 others participated in the said election. The first respondent accordingly declared the second and third respondents winners of the election and declared the second respondent as the elected president of the Federal Republic of Nigeria. Aggrieved by the outcome of the election, the petitioners jointly filed a petition at the court below to challenge the outcome of the election under 4 grounds as follows. A, that the election of the second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. B, that the election of the second respondent is invalid by reason of corrupt practices. C, that the second respondent was not duly elected by a majority of lawful votes cast at the election. And 4, the second respondent was at the time of the election not qualified to contest the election. The appellants as petitioners then sought the following reliefs. 1, that it may be determined that the second respondent was not duly elected by a majority of lawful votes cast in the election, and therefore the declaration and return of the second respondent by the first respondent as the winner of the presidential election conducted on the 25th day of February 2023 is unlawful, wrongful, unconstitutional, undue, null and void, and of no effect whatsoever. That it may be determined that the return of the second respondent by the first respondent was wrongful, unlawful, null and void, having not satisfied the requirements of the Electoral Act 2022 and the Constitution of the Federal Republic of Nigeria 1999 as amended, which mandatorily requires the second respondent to score not less than 1/4 or 25% of the lawful votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja. that it may be determined that the second respondent was at the time of the election not qualified to conduct the said election, to contest the said election. That it may be determined that the first petitioner, having scored the majority of lawful votes cast at the presidential election on Saturday, 25th February 2023, be returned as the winner of the said election and be sworn in as the duly elected president of the Federal Republic of Nigeria. In the alternative, number 5, an order directing the first respondent to conduct a second election that is run-off between the first petitioner and the second respondent. In the further alternative, 6, that the election to the office of the President of Nigeria held on the 25th of February 2023 be nullified and a fresh election rerun ordered, and any further reliefs as the court may deem fit to make in the interest of justice. Upon being served with the petition, all the respondents joined issues with it by filing their respective replies, incorporating preliminary objections, and made other applications. Some of the applications filed by the parties were heard and rulings delivered at the pre-hearing stage, while some were heard and rulings on them reserved till the time of the judgment of the court. On 6 September 2023, judgments in the petition, including rulings in the applications, were rendered by the court below. As I said earlier, the appellant's petition was dismissed. Dissatisfied with the stance of the lower court dismissing their petition, the appellants have appealed to this court. Notice of appeal was filed on the 18th of September 2023, containing 35 grounds of appeal. Appellants filed their brief of arguments on 2nd October 2023, while the first, second, and third respondents filed theirs on the 7th of October, respectively. On 6th October 2023, the appellants filed a motion on notice seeking 2 orders from this court. And at the hearing of the appeal on 23rd October 2023, the said motion was taken first and ruling reserved till today. I shall proceed to determine the said motion before resolving the issues in this appeal. Motion on notice filed on the 6th of October 2023. As I alluded to above, the appellants filed motion on notice on 6 October 2023, seeking 2 orders from this court, to wit, A, an order of this honorable court granting leave to the appellant applicants to produce, and the honorable court to receive fresh and or additional evidence by way of deposition on oath from the Chicago State University for use in this appeal, to wit, certified discovery deposition made by Caleb Westberg on behalf of Chicago State University on October 3rd, 2023, disclaiming the certificate presented by the second respondent, Bola Ahmed Tinubu, to the Independent National Electoral Commission. B, and upon leave being granted, an order of this court receiving the said deposition in evidence as exhibit in the resolution of this appeal. The grounds for the application are well set out in the motion paper, and there are 20 in number as follows. 1. One of the grounds of the applicant's petition before the court below is that the second respondent was not qualified at the time of the election to contest the election, as required by Section 137(1) sub 1 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. 2. Based on facts available to the appellant's applicants at the time of filing their petition, the first appellant applicant through his United States of America lawyers, Alexander de Gramont and Angela M. Liu of the law firm of Dockett LLP of 1900 K Street, NW, Washington, D.C., 20006 to 1110, unsuccessfully applied to Chicago State University for the release of the copies of the academic records of the second respondent. Given this, number three, given the strict privacy laws in the jurisdiction of the Chicago State University, the request for the release of the academic records and certificates issued to the second respondent could not be granted without an order of court and for the purpose of use in pending court proceedings. The first applicant, through his said U.S.-based attorneys, thereupon brought an action in the U.S. District Court for the Northern District of Illinois in re application of Atiku Abubakar for an order directing discovery from Chicago State University, case number 23-CV-05099, for an order for the production of documents and testimony for use in a proceeding in a foreign court, seeking documents and testimony from Chicago State University concerning the authenticity of an origin of documents purporting to be the educational records of the second respondent, Bola Ahmed Tinubu. 5. The second respondent applied and was joined in the matter as an intervener, vehemently opposing the application. On September 19, 2023, the court issued an order granting the application. 7. Thereafter, the second respondent applied for an emergency stay of the court order, claiming that he would suffer irreparable damage and injury if his educational records were released, which order of stay was granted. 8. On September 30, 2023, the court overruled the second respondent's objections and ordered Chicago State University to produce the documents on October 2nd, 2023, and to produce a witness for deposition on October 2. Then on October 2, 2023, Chicago State University produced the documents pursuant to the court's order. 10. On October 3, 2023, also pursuant to the court's order, Chicago State University provided a witness to give deposition testimony, in which deposition Chicago State University disclaimed ownership and authorship of the document that second respondent presented to INEC, purporting to be Chicago State University certificate, and also disclaimed issuing any replacement certificate to him. The deposition was not in existence, or that's number 11. The deposition was not in existence or available at the time of filing the petition or at the hearing of the petition. The deposition number 12 sought to be adduced is, along with its accompanying documents, such as would have important effect in the resolution of this appeal. 13. The deposition is relevant to this matter, having confirmed that the certificate presented by the second respondent to the Independent National Electoral Commission did not emanate from Chicago State University, and that whoever issued the certificate presented by the second respondent did not have the authority of the Chicago State University, and that second respondent never applied for any replacement certificate, nor was he issued any replacement certificate by Chicago State University. The deposition which is on oath, that is number 14th ground, the deposition which is on oath deposed to in the presence of the second respondent's attorney is credible and believable and ought to be believed. 15. The deposition is clear and unambiguous, and no further evidence is needed to be adduced on it. 16. The evidence is such that could not have been obtained with reasonable diligence for use at the trial, as the deposition required the commencement of the suit in the United States of America before receiving same. It was not possible to obtain the said evidence before the trial at the court below. 17. The deposition was made on October 3, after the conclusion of trial at the court below, and was not available to be tendered at the trial court. 18. Presentation of a forged certificate to the INEC by a candidate for election to the office of President of the Federal Republic of Nigeria is a weighty constitutional matter requiring consideration by the court as custodians of the Constitution. 19. The original certified deposition has been forwarded to the Honorable Court by a letter addressed to the Chief Registrar of the Supreme Court. And 20, the last, it is in the interest of justice for this Honorable Court to exercise its discretion in favor of the appellant's applicants. In support of the said application is a 20-paragraph affidavit deposed by Uyigiwa Osage, Nigerian citizen, a legal practitioner, and legal advisor to the first appellant, with exhibits A to H annexed. Learned Senior Counsel for the appellant applicants, Chief Chris Uche, SAN, leading other senior and other counsel, filed a written address in support of the motion. Upon receipt of the said motion on notice, the first respondent filed an 11-paragraph counter affidavit deposed by one Gift Nwadike, a legal secretary in the law firm of Diko and Mahmood, lead counsel to the first respondent. A written address in opposition to the said motion was also filed and signed by A.B. Mahmood SAN, lead counsel for the first respondent. For the second respondent, Senator Michael Okpeyemi Bamidele, a legal practitioner and long-standing associate of the second respondent, deposed to a counter affidavit of yet again 20 paragraphs on 12 October 2023. Annexed to the counter affidavit are exhibits 1 to 9. And in support of the counter affidavit and in opposition to the motion, Learned Senior Counsel for the second respondent, Chief Wole Olanipekun SAN, leading senior counsel and leading other counsel, filed a written address on the same date the counter affidavit was filed. The third respondent's counter affidavit was deposed to by one Peter Emma Iko, a legal executive in the law firm of Olujinmi and Akeredolu, lead counsel for the third respondent. The 9 paragraphs counter affidavit is supported by a written address filed and signed by Chief Akin Olujinmi SAN. Upon receipt of the various counter affidavits, the appellants filed a further affidavit of 20 paragraphs deposed to by the same Uyi A. Giwa Osage, with 12 exhibits further annexed. Learned Senior Counsel also filed reply on points of law to the written addresses filed by the first, second, and third respondents in their opposition to the applicant's motion on notice for fresh evidence and or additional evidence. At the hearing of this motion, both the applicants and the respondents adopted their supporting and counter affidavits respectively. They also adopted and relied on their various written addresses. In the applicant's written address, the Learned Senior Counsel submitted one issue for determination, to wit, whether this Honorable Court ought to exercise its discretion in favor of the appellant applicants by granting the prayers sought. The first respondent's Senior Counsel also donated a sole issue for determination as follows: whether in view of the peculiar facts of this case, this Honorable Court can proceed to grant the instant application. For the second respondent, Chief Olanipekun SAN, submitted one issue, which states, Considering the background of this case, as well as the applicable constitutional and statutory provisions relevant to election appeals and proceedings, whether this Honorable Court will grant this application. Finally, Chief Akin Olujinmi SAN, leading other counsel for the third respondent, opined that the crucial question to be addressed in this motion is whether this court has jurisdiction to entertain this application. Now, taking a clinical look at the four issues, it is crystal clear that they all say the same thing. And put in simple terms, it is whether the law of Nigeria, as presently constituted, allows this court to receive the evidence in question and act on it at this stage. In his argument, the learned senior counsel for the appellants submitted that this court has the power, the jurisdiction, and the discretion to grant an application to adduce fresh and/or additional evidence on appeal, referring to Order 2, Rule 12.1 and 2, and Rules 12.1, 2, and 3 of the Supreme Court rules, and the case of Uzodinma and Izunaso, citation supplied, learned senior counsel submitted that the grant of this application will be in furtherance of the cause of justice. That this is a case in which the second respondent was purportedly declared as the winner of the election to the office of President of the Federal Republic of Nigeria, and the applicants have, amongst other grounds, challenged the election of the second respondent on the ground that the second respondent presented a forged document to the Independent National Electoral Commission. That the appellants have also a challenge in their appeal, the striking out of their pleadings, raising the issue of qualification of the second respondent to contest the said election. Learned Silk also relied on the cases of Nigerian Customs Service Board and Innocent and other cases cited in this judgment. According to the Learned Silk, the evidence required to establish that the certificate presented by the second respondent to the first respondent in support of his qualification to contest the said election is the deposition from the Chicago State University, which deposition did not become available until after the determination of the case by the lower court. He contended that the appellant applicants have successfully explained the delay and difficulties in obtaining the said evidence earlier than now. Relying on Saleh and Abba citations supplied, the learned senior counsel urged this court to resolve the sole issue in favor of the appellants and grant the application. In response to the above argument, the learned senior counsel for the first respondent, A.B. Mahmoud Essay, submitted and urged this court to dismiss the appellant's application as they have failed to meet the conditions for grant of same. He opined that election petitions are sui generis, and as such, this court, in determining this application, must take into consideration the peculiarity of the instant appeal, which is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court, and based on the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the Electoral Act 2022. He stated the three conditions that has to be met before the fresh evidence can be admitted, and he urged this court to hold that the appellant's applicants failed to fulfill the conditions. In this, he relies on the case of Adeleke and Aserifa, Wata and Anyago, UBA PLC and BTL Industries, all citations supplied, amongst others. It is his contention that the appellants were tardy and were not reasonably diligent in their attempt at obtaining the documents which they seek to be received in these proceedings, that having not acted with reasonable diligence, this court ought not to grant the instant application, also relying on Obo and NFL S Limited. Oh my God. Learned Senior Counsel also drew the attention of this court to the decision of the court below, which has not been appealed against, that the petition did not plead facts in support of non-qualification or disqualification of the second respondent in their petition, and that their efforts to remedy it through their replies to respondents' replies were belated and were rightly refused. According to him, the deposition of Caleb Westberg is irrelevant since the appellants did not raise the issue of forgery at the lower court. And relying on the case of Okwe Kenye and registered trustees of Jude Anglican Church, citation supplied is submitted that evidence not supported by pleadings goes to no issue. Learned Silk further submitted that insofar as the deposition of Caleb Westberg is solely to disdain the certificate presented by the second respondent and attached to his form EC9 dated 17 June 2022, which the first respondent published as far back as 24th day of June 2022, the appellant's complaint in that regard is pre-election matter, which by section 285(9) of the Constitution of the Federal Republic of Nigeria is statute barred. As such, an action ought to have been initiated within 14 days of the second respondent's submission of his form EC9 or the publication by the first respondent. He urged the court to so hold. According to Learned Senior Counsel, an allegation of presentation of false or fake certificate is rooted in the criminal offense of forgery, which requires proof beyond reasonable doubt. He contended that the deposition by Caleb Westberg, which seeks to establish a case of forgery against the second respondent without more, cannot ground a conviction for forgery of as proof beyond reasonable doubt cannot be solely based on an affidavit evidence, relying on Abubakar and INEC, Agi and PDP, Mohammed and Wamako, all citations supplied. Learned Silk argued further that the deposition of Caleb Westberg alone does not, under our law, constitute credible evidence to establish a case of forgery. Finally, the Learned Silk submitted that this appeal, being based on an election matter, where a trial court is to hear matters and deliver judgment not later than 180 days after the filing of the petition, the implication is that all evidence ought to be adduced at the trial court and judgment delivered within 180 days. That it was not the intention of the draftsman of the Constitution to allow and permit the receipt of evidence in an election matter when the court vested with the powers to receive evidence, has lost jurisdiction over the matter. He wondered what would happen now that all parties have filed and exchanged briefs with no arguments canvassed in respect of the additional evidence sought to be adduced in the instant appeal. There being no room to extend time under the pre-election and election appeals practice directions 2023 of the Supreme Court, he urged the court to dismiss the application. In his contribution in opposition to the grant of this application, Learned Senior Counsel for the second respondent, Chief Olanipekun S.A.M., submitted that this court is without the virus to consider the said deposition, either as oral or documentary evidence, more so when the evidence was not considered by the court of first instance within the 180 days time frame provided by the Constitution of the Federal Republic of Nigeria, relying on the recent case of Towo Womo and Ajayi, unreported, delivered on the 27th of January 2023 in this court hall. That the lower court, having lost its jurisdiction since 17 September 2023, upon expiration of the 180 days from the date of filing the petition by the appellant, this court cannot grant this application. That section 22 and 23 of the Supreme Court Act give power to order 2 Rule 12(1) of the rules of this court, and that can only happen if the lower court still has jurisdiction. Referring to Omubilari and Igbo Asoi, and others, and Adegbite and Omosun, all citations supplied, the learned contended that applicants failed to satisfy the 5 conditions enunciated in those cases before this type of application can be granted. According to the learned SAN, the failure of the applicants to have validly pleaded facts and documents sought to be received in evidence is fatal to this application, relying also in Obasi and Omuka, Start Oil, Nigeria Limited and Induction, and others, all citations supplied. Making reference to the USA Rules on Civil Procedure 32A1A, the learned Silk opined that the failure to invite the All Progressives Congress and the Independent National Electoral Commission to participate in the deposition made in the United States renders Exhibit C and D inadmissible. More so, since the alleged forged certificate is alleged to have been submitted to INEC. It is further contention that Exhibit C and D have no utility or affinity with this appeal for the fact that there is no ground of appeal upon which they can be structured, as well as there being no accommodative issue for determination, relying on a number of cases listed in this judgment. Finally, learned senior counsel submitted that Exhibit C, D, unpretentiously attempts to allege a criminal offense of forgery against the second respondent. You find that a criminal offense must be proved beyond reasonable doubt, as provided in Section 135 of the Evidence Act, also referring to the cases of ACN and Nyako and Kaki and PDP. He concluded that the Supreme Court does not have original jurisdiction to try the case of forgery. He urged this court to refuse this application and hold that it is an abuse of court process. For the third respondent, Chief Akin Olujimi SN made submissions which are similar to those by the learned counsel for the first and second respondents. With due respect to the learned Chief Silk, I shall refer to them in the process of resolving the sole issue in this application. In the applicant's reply on points of law, learned senior counsel listed some paragraphs of counter affidavit of the second respondent, which he alleges consists of legal arguments, objections, and conclusions, which he urged that they be struck out. On issue of jurisdiction, he submitted that Section 285(6) of the Constitution, which pegs 180 days for the hearing and determination of the election petitions, does not include the Court of Appeal, but only election tribunals. Learned Silk submitted that issue of qualification is for both pre- and post-election matters, referring to Section 137(1)J of the Constitution. He urged the court to grant this application in the interest of justice, as was done in Amechi and INEC and Obi and INEC, all citations supplied. In resolving the sole issue submitted for the determination of this motion, I wish to start from the beginning. And the beginning is the issue of jurisdiction. Whereas the respondents in their various written addresses have urged this court to grant not to grant this application as it is an exercise in futility. They opine that the Supreme Court does not have jurisdiction to look into or act on Exhibit C and D if admitted into the proceedings. The learned senior counsel for the appellants submitted otherwise. I have already summarized their various positions, and I shall refer to them as we proceed. It is elementary to state that the jurisdictional court is the authority which a court possesses to decide matters brought before it, or to take cognizance of matters presented in a formal way for its decision. In an old case of Ogun Makun and Milad Osun State, citation supplied, this court stated as follows: jurisdiction of the court is the basis, the foundation, and the live wire of access to court in adjudication under Nigerian civil process. As courts are set up under the Constitution, decrees, acts, laws, and edicts, they cloak the courts with the powers and jurisdiction of adjudication. If the Constitution, decrees, acts, laws, and edicts do not grant jurisdiction to a court or tribunal, the court and the parties cannot, by agreement, endow it with jurisdiction, as no matter how well intentioned and properly conducted the proceedings, once it is incompetent, it is a nullity and an exercise in futility. End of quote. The jurisdiction of a court has further been defined as the very fundamental and priceless commodity in the judicial process. That is to say, it is the fulcrum, the centerpiece, or the main pillar upon which the validity of any decision of any court stands and around which other issues rotate. Thus, it cannot be assumed or implied. It cannot also be conferred by a party or by consent or acquiescence of parties. A lot of cases have been cited to support this. This and that is the general nature of jurisdiction. I must emphasize that the matter under which the application is brought is an appeal in an election petition. It is tried that election petition proceedings are sui generis. It has its own set of laws and rules which a court must recognize and enforce. See Buhari and Yusuf, Egbarioba and Erobo, all citations supplied. In the circumstance of this case, this court, in determining this motion, has to take into consideration the peculiarity of the instant appeal, which is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court, based on the provisions of the Constitution of the Federal Republic of Nigeria and the Electoral Act 2022. I have carefully perused page 1 of volume 1 of the Record of Appeal, and it is very clear that the petition giving birth to this appeal, and particularly this application, was filed on the 21st of March 2023, which was the last day of the 21 days prescribed in Section 285, Sub 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, for filing of election petitions after announcement of result of election. By subparagraph 6 thereof, an election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition, and where there is an appeal, it shall be determined within 60 days from the date of delivery of judgment of the tribunal or court of appeal. As pointed out by learned senior counsel for the respondents, the 180 days prescribed for the hearing of the petition by the Court of Appeal lapsed on the 17th of September 2023. In other words, the court below lost its jurisdiction to determine any matter in relation to the petition. This application before us relates to fresh evidence obtained after the judgment of the lower court and after the 21 days for filing election petition and after the expiration of the 180 days of the filing of the petition. What are the legal and or constitutional implications of the above scenario in relation to Exhibits A and D sought to be received into these proceedings? Several of the decisions of this court have taken care of the above scenario. One of the most recent cases decided by this court is the case of Towo, Womo, and Ajayi, the citation supplied here, wherein this court stated as follows, and I'll quote, In the circumstance of this case, this court cannot activate Section 22 of the Supreme Court Act 2004, since the 180 days provided by the Constitution to determine the appellant's claim at the trial court has lapsed since 1st January 2023. The originating summons was filed on the 5th of July 2022 and expired on 1st January 2023 at the Federal High Court. This appeal was taken on 2nd January 2023, and there is no opportunity for the contentious issues of fact in the controversy in this appeal to be sent back to the trial court. The issue of the merit of the allegations of false information was not tried by the two lower courts and cannot be tried by this court pursuant to Section 22 of the Supreme Court Act. This court cannot do what the trial court is no longer constitutionally permitted to do by virtue of Section 285 of the Constitution of the Federal Republic of Nigeria, the Groundnum. See OK, Mimiku, see APC and Marafa, all citations supplied. As stated by the appellant applicants in their application, the reliefs they seek is an order of this court granting them leave to produce, and for this court to receive fresh or additional evidence by way of deposition on oath. Clearly, the application runs foul of paragraphs 14 sub 2 and 16.1 of the first schedule to the Electoral Act, which inter alia outlaws any amendment of substance, as in this case, or introduction or addition of substance to the statement of facts relied on to support the ground of the petition after the expiration of 21 days prescribed in Section 132, sub 7 of the Electoral Act for the presentation of an election petition. There is no doubt that the deposition is one of substance, and that is in fact why the appellants are seeking to introduce it into this appeal. For the avoidance of doubt, I shall reproduce Section 14.2, paragraph 2A of the first schedule to the Electoral Act 2022 as follows. After the expiration of the time limited by A, Section 132(7) of this Act for presenting the election petition, no amendment shall be made. No amendment shall be made. 1. Introducing any of the requirements of paragraph 4.1 not contained in the original election petition filed. Or 2. Effecting a substantial alteration of the ground for or the prayer in the election petition. Or 3. Except anything which may be done under subparagraph 2A2, effecting a substantial alteration of or addition to the statement of facts relied on to support the ground for or sustain the prayer in the election petition, end of quote. Nothing can be clearer than the above provision, which clearly states that a petitioner shall not be permitted to amend his petition after 21 days allowed by Section 132 sub 7 of the Electoral Act. The applicants herein have not even applied to this court to amend their petition in order to reflect the fact of forgery, and Exhibit C and D sought to be admitted into the proceedings. Facts and documents which were not pleaded in the petition have no place in deciding the dispute between the parties. I still wonder how the appellants intend to use those documents in this appeal. Let me consider an unusual submission of the learned senior counsel for the appellants applicants. It is in respect of Section 285 sub 6 of the Constitution, which states, an election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition. But on page 3, paragraph 2.5 of the appellant's reply on points of law, he argued as follows, quote, interestingly, and contrary to the avowed position of the respondents, we make bold to submit that there is no such constitutional limit of 180 days on the lower court to hear and determine a presidential election petition, such that can rob this court to exercise its jurisdiction in any manner whatsoever. While establishing the election tribunals to deal with election matters from houses of assembly, National Assembly and governorship elections, the Constitution gave jurisdiction to entertain disputes from presidential elections only to the Court of Appeal. Thereafter, the Constitution was intentional and deliberate in setting the 180 days limit only for elections tribunals and not for the Court of Appeal, end of quote. It is shocking to have the above argument in print. It could have passed for a friendly joke, but not for a serious matter like this in the apex court. It is even an unnecessary joke over a constitutional provision. After election petitions had suffered under the previous provisions, which allowed election petitions to be heard even until the respondent has completed his tenure, and the National Assembly dealt with the mischief by limiting the time which election petitions shall be determined, it is unfair to suggest that we go back to those dark days. My lords, there is nothing in section 285(6) of the Constitution to suggest that the Court of Appeal can hear presidential election petition without time limitation. The lower court is bound by the provision of section 285 sub 6 of the said Constitution when sitting to hear election petition, just as other election tribunals, as was rightly submitted by the learned senior counsel for the third respondent, Chief Akin Olujimi SAN, for which I wholly agree. The appellants knew they had to prove the allegation of non-qualification raised at paragraph 16D and 146 of their petition against the second respondent within the 180 days adjudication window provided in section 182 sub 8 of the Electoral Act 2022 for determination of petition by the lower court, which expired since 17 September 2023. The 180 days having expired, the lower court therefore no longer had jurisdiction to allow the deposition sought to be introduced into the trial of this petition. This is the law which at this stage is elementary. Consequently, since the lower court no longer has jurisdiction to entertain any such application, it follows ipso jure that this court, this Supreme Court, also has no jurisdiction to allow the deposition to be used in this appeal. It is settled law that where the time for doing a thing is limited by the Constitution or statute, the court cannot extend the time. That was the decision of this court in Brigadier General Mohammed Buba Mawar and Admiral Mortala Nyako, where Onogan JSC, as it then was, held as follows. Quote, it is settled law that the time fixed by the Constitution for the doing of anything cannot be extended. It is immutable. It is fixed like the Rock of Gibraltar. It cannot be extended, elongated, expanded, or stretched beyond what it states. See also Abubakar and Nasamu, all citations supplied. It has to be noted, as I stated earlier in this ruling, and for which there are several judicial decisions in this country, that the 180 days imposed on election tribunals and courts hearing election petitions is immutable and cannot be extended. The applicants have not even applied for extension of time to bring in the said depositions or extension of time to amend their petition. Let me say it clearly. that 21 days provided for the filing of petitions having long expired, even if the appellants had applied for extension of time to amend their petition in order to bring in the depositions, it would not have been granted based on the provisions of the Constitution and the Electoral Act. This principle was again restated by yet again Onogen JSC as it was in NNPP and Goni. Citation supplied. When he said, despite the decision of this court since October 2011 on the time fixed in the Constitution, some of the justices of the lower court still appear not to have gotten the message. From where will the election tribunal get the jurisdiction to entertain the retrial after expiration of the 180 days assigned by the Constitution? The answer is obviously in the negative. It should be constantly kept in mind that prior to the provisions of Section 285(6) of the 1999 Constitution as amended, there was no time limit for the hearing and determination of election petition by the election tribunals or the appeals arising therefrom. That situation resulted in undue delay in the hearing and determination of an election petition by the election tribunals or appeals arising therefrom. The amendment to the original Section 285 of the 1999 Constitution, by allotting time within which to hear and determine election petition and appeals arising therefrom, is designed to ensure expeditious hearing and conclusion of election matters. If the decision of the lower court is allowed to stand, as urged by the respondents, it will reintroduce the earlier mischief which the amendment sought to correct. End of quote. See also Uba and Suswan. Citation supplied. The above statement by this court is very explicit, clear, and simple. As it is, the provision of the Constitution has spoken. There cannot be an addendum or another reopening of the case at the lower court, its jurisdiction having lapsed. My noble lords, I've taken time to state the law on the issue to show the futility of this motion. It cannot be granted. The jurisdiction of this court is donated by the Constitution and the Electoral Act regarding election petition appeals. We do not have the virus to admit this position, and we cannot invoke Section 22 of the Supreme Court Act, since the lower court has since lost its jurisdiction. More so, there is no paragraph of the petition to accommodate a case of forgery. Again, the appellants have distilled 7 issues for the determination of this appeal, and none relates to certificate forgery. One wonders what the appellants intended to do with the deposition, since appeals are heard on the issues distilled for determination by the parties in this court. In Saliba and Jasin, 2002, for Nigeria Will Report, citations, others supplied. This court stated clearly that all appeals are decided upon the issues formulated for determination. What this means is that any matter not covered by any issue for determination is of no moment. Should the deposition be admitted, it will float in the appeal, as this court cannot exercise original jurisdiction even if we are to start a new case for the appellants. See Sanusi and Ayula, Chitex Industries, and Oceanic Bank, citations supplied. Finally, my noble lords, on this application, I wish to state that fresh evidence is not received as a matter of course. There are conditions which must coexist before the court can grant this type of application, as can be garnered from the decided authorities of this court, which include, but not limited to Omu, Buariri, and others, and Igbo, Oyosi, and others, Supra. Adegbite and a motion are cases cited by the Senior Counsel by the second respondent. Simply put, the conditions for the grant of this type of application are that 1, The fresh evidence could not have been obtained with reasonable diligence at the trial. 2. Such evidence, if admitted, would have important effect on the subject of the appeal. 3. Such evidence ex facie is apparently capable of being believed. 4. Such evidence would have influenced the judgment of the lower court in favor of the appellants had it been available. And 5. And if such evidence is admitted, further evidences from the opposing party would not be needed. Taking the first condition, for example, the appellants failed to convince this court on why it waited until after the court below delivered judgment in the petition and lost the 180 days donated to it by the Constitution before bringing the said deposition sought to be admitted in this court. It has to be noted that appeals are a continuation of hearing of the matter in the lower court. As was pointed out by the learned senior counsel for the first respondent, A.B. Mahmoud Essay, the presidential election was conducted on the 25th of February, 2023. And the first respondent declared the second respondent as winner of the election on 1st March 2023. Thereafter, the appellants filed their petition at the registry of the court below on 21st March 2023. If I may ask, what attempts did the appellants make between the publication of the second respondent's form EC9 and accompanying documents in June 2022, more than a year ago, and the date of filing the petition on 21st of March 2023 to obtain the documents from Chicago State University, which could have been used at the trial court? Again, what attempts did the appellants make to obtain these documents between the date of filing the petition and the conclusion of trial? To say the least, the above questions are critical in the quest of this court's efforts to decide whether the new evidence sought to be adduced could have been obtained by the appellants with reasonable diligence for use at the trial. And with due respect to the appellants, their counsel, I think they were a bit tardy and were not reasonably diligent in their attempts at obtaining the documents which they seek to have this court receive in this appeal. In Adeleke Aserifa Supra, this court held that where the evidence is available and could with reasonable care and diligence be made available to the applicant at the time of the trial, as in this case, the court should refuse to exercise its discretion to receive such evidence. From all I have stated above, it is crystal clear that the additional evidence by way of deposition of oath does not fit into the issues submitted for the determination of this appeal. The application, my lord, of the appellant applicants in the circumstance is hereby refused and accordingly dismissed. I now go to the main appeal. I want to say that the motions filed by the respondents to challenge some issues, grounds of appeal, we have decided to ignore them, strike them out, and hear the appeal on the merits. The latest senior counsel for the appellants distilled 7 issues for determination, all of them, except the last one, the third respondent submitted 6 issues. So we have stated all there are 7 issues in the judgment. You will see them when you get copies. There is no doubt that all the issues submitted by all the parties are similar, and any could be adopted for guidance. I propose, however, to determine this appeal based on the issues as formulated by the appellants. After all, it is their own appeal. Issue 1. The thrust of issue 1 is whether the lower court was right in refusing to hold that the failure of the first respondent to electronically transmit results from polling units nationwide for the collation of results introduced by the Electoral Act 2022 and specified in the regulations and guidelines for the conduct of elections 2022 and manual for election officials 2023 does not amount to non-compliance, which substantially affected the outcome of the election. Chief Krisuche, SAN, learned senior counsel for the appellants, submitted in the main that by virtue of Section 64, Sub 4 of the Electoral Act 2022, the collation officers and returning officers of the first respondent, including the national chairman of the first respondent, were under a statutory obligation towards mandatory verifications and confirmations at all stages required before the announcement of the results of the election. Learned Silk further contended that at the trial of the appellant's subpoenaed witnesses, several INEC presiding officers, including PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25, who handled the BVAS machines at the polling units on the election day, who confirmed the non-transmission of results of the presidential election electronically from the BVAS machines, whereas the results for the National Assembly election held simultaneously were electronically transmitted without difficulty. That the appellant's witnesses gave evidence that the bypass of the use of the prescribed verification technology was nationwide, affecting the entire polling units and collation of results all over Nigeria, and substantially affected the outcome of the election. That the sole witness of the first respondent, Lawrence Biode, admitted under cross-examination that the deployment of the technology of BVAS and IREV was to guarantee the transparency of the electoral process and the integrity of the results, but claimed that there was a technical glitch that made the system fail to work on the election day, which technical glitch was not explained by the first respondent. The appellant contended that the failure to transmit the results electronically led to manipulation of the results in favor of the second respondent. Learned Silk then urged this court to depart from its previous decisions pursuant to Order 6 Rule 54 of the Supreme Court rules on the manner of proof of non-compliance with the provisions of the Electoral Act in the light of the novel provision in Section 132 of the Act and paragraph 46 of 4 of the first schedule to the Electoral Act. The learned SAN submitted that the assurances given to the public by the first respondent as a public institution that results will be electronically transmitted was dashed. It is his contention that the election ought to be nullified by reason of the gross misrepresentation by the first respondent based on the doctrine of legitimate expectation as applied by this court in Stitch and AG Federation. Citation supplied. The learned Silk concluded on this issue that given the introduction of technology into the collation process by the new Electoral Act 2022, the judicial approach and attitude must of necessity be different from the analog past. He then invites this court to depart from its decisions on mode of proof of non-compliance with the Electoral Act in election petitions, as was the case in Nyesom Wike and Peterside, Okereke and Umahi, Shinkafi and Yari, amongst others. He urged the court to resolve this issue in favor of the appellants. In response, the learned senior counsel for the first respondent, A.B. Mahmoud Hussain, urged this court to decline the invitation to override its previous decisions on the manner of proof of non-compliance because such invitation is not usually taken lightly by this court. He contended that the conditions for such application does not exist in this appeal, relying on VP Industries Limited and Cocoa Industries Limited, citation supplied. He contended that the appellant has not contended that the previous decisions sought to be departed from were given per incuriam or erroneous in law. On the argument that first respondent failed to electronically transmit results, he submitted that the only reference to electronic transmission of polling unit results appears in paragraph 38(1) of the guidelines published by INEC for the conduct of the election, wherein it provides that presiding officers shall electronically transmit or transfer results of the polling units directly to the collation system prescribed by the first respondent. That the use of the word "or" in the said paragraph 38(1) of the guidelines gives the presiding officer the discretion or option to either transmit electronically or transfer the result to the collation system prescribed by the first respondent. Learned Senior Counsel submitted that the main complaint of the appellants relates to the alleged failure to transmit the election result to the IREV portal for members of the public to view, and that this amounts to non-compliance. He submitted that the IREV portal is only a public viewing portal and not a collation portal, relying on Oyetola and INEC citations supplied. He urged the court to hold that the failure did not substantially affect the result of the election, which was properly collated and result announced. In his argument, Chief Olanipekun SN, for the second respondent, submitted that by all extant relevant laws, INEC has the prerogative of determining the mode and manner for the transmission of election results, and that the lower court was perfectly right and in order when it so held. He faulted the appellant's claim and basis of allegation of non-compliance with respect to the presidential election in focus on their claim that the results of the election results were not electronically transmitted to the IREV in real time, not that it was not transmitted at all, and that the first respondent did not ensure that the results were collated on the IREV. He also faulted the appellant's insistence that the results ought to have been collated electronically on the IREV, and that omitting to do this automatically nullified the result of the election. Referring to the case of Labour Party and INEC, suit number FHC ABA-CS 145/2022, delivered on 23/1/2023 by Wite J of the Federal High Court, which decided that there is nothing in a combined reading of sections 47(2), 52, 65, and 62(1) and 2 of the Electoral Act 2022, which suggests that INEC is mandated to only use an electronic means in collating or transferring of elections result. Rather, that INEC is at liberty to prescribe the manner in which election results will be transmitted. That by section 287(3) of the 1999 Constitution, all authorities and persons are bound to enforce the terms of the judgment until set aside by an appellate court. It submitted that all through the gamut of the Electoral Act, the appellants were unable to refer to the lower court a single provision which prescribed electronic collation of result or even electronic transmission of result, and that was why the court below held that the petitioners were unable to prove that the Electoral Act or guidelines made it mandatory for electronic collation system. He submitted further that the appellants failed to show that the results collated was different from the one they perceived belonged to them. Learned Soul submitted finally that the Electoral Act 2022, the INEC regulations and manual points irresistibly to a manual collation of results contrary to electronic collation touted by the appellants. The reason being that by paragraph 93 of the regulations, the only circumstance where electronic copy of results becomes relevant is where there is no hard copy of the result. Then the electronic copy can be resorted to during collation. Learned Counsel Olanipekun urged this court to resolve this issue against the appellants. In his submission, Chief Olujimi SN, for the third respondent, submitted that the appellants seem to have admitted their failure to prove allegation of non-compliance when they pleaded with this court to depart from the earliest established legal position that non-compliance be proved on polling unit basis. He submitted that there is nothing compelling presented by the appellants to warrant a departure from the established legal order, relying on Wike and Peterside, Belgore and Ahmed citations supplied. He urged this court to decline the invitation. According to Leonard Silk, any agreement for relaxing the established standard of proof of allegation of non-compliance must not be driven by sentiments and cavalier presentation of a case seeking to overturn the will of millions of the electorate in a presidential election. He contended that the appellants merely half-heartedly offered 27 witnesses, many of whom were incompetent witnesses, while purporting to prove allegation of non-compliance covering 176,000 polling units spread across the 36 states that make up the Federation of Nigeria. He argued that based on the inadequate evidence, the allegation of non-compliance must fail, relying on Buhari and Obasanjo, Atiku Abubakar, and INEC, all citations supplied. He urged the court to resolve this issue against the appellants. In their reply brief, the learned senior counsel for the appellants faulted the response of the respondents in relation to their call for this court to depart from its previous decision touching issue of non-compliance. According to him, his argument is based on the introduction of Section 65 and 6 and 187 of the Electoral Act 2022 and paragraph 46 or 4 of the first schedule to the Electoral Act, which provisions were not in the 2010 Electoral Act, that these new provisions deal with the new manner of transmission of result as contained in paragraph 38(1) and 2 of the Regulations and Guidelines for Conduct of Elections 2022 and the legislative intervention to reduce calling of numerous witnesses. This is what the court has to say. By Section 135, sub 1 of the Electoral Act 2022, an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this Act if it appears to the election tribunal or court that the election was conducted substantially in compliance with the principles of the Act and that the non-compliance did not affect substantially the result of the election. From the provisions of the Act stated above, it is crystal clear that a petitioner seeking to nullify an election on the ground of non-compliance must not only lead evidence to prove the non-compliance, but must also show to the court how the non-compliance substantially affected the outcome of the election. A petitioner in this situation must therefore adopt a kind of double-barrel approach. You don't fire one barrel and leave the other intact. Both must be fired together at the same time. From the evidence as can be garnered from the record, the judgment of the court below and the arguments of both parties in this appeal, one thing is very clear, and that is the appellants abandoned the duty imposed on them to lead credible evidence to prove non-compliance, but relied solely on the failure of the first respondent to transmit result real-time to the IREF portal. According to the appellants, this was enough to nullify the election of the second respondent. What exactly is the IREF portal? The court below held that the IREF portal is not a collation system. This court in Oyetola and INEC made it clear that there is a difference between a collation system and the IREF portal, though both are part of the election process. Whereas the election system is made up of the centers where results are collated at various stages of the election, the INEC result viewing portal is to give the public the opportunity to view the polling unit results on the election day. What this means is that where the IREV portal fails, it does not stop the collation of results, which up to the last election was manually done. The failure or malfunctioning of the IREV deprives the public and even election administrators and monitors the opportunity of viewing the portal and comparing the result collected with the ones transmitted into the IREV. Truth must be told, the non-functioning of the IREV may also reduce confidence of the voting public in the electoral process. My lords, the Electoral Act empowers the first respondent to determine the electronic device to be used during election and their purpose. The lower court held that the IREV is not a collation system, and I agree. I refer to paragraph 93 of the first respondent's guidelines and regulations for election, which provides that, and I quote, where the INEC hard copy of collated results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the IREV portal to continue collation. When none of this exists, the collation officer shall ask for duplicate hard copies issued by the Commission to the following in the order below. 1, the Nigeria Police Force, and 2, agents of political parties. End of quote. Paragraph 93 of the first respondent's guidelines and regulations reproduced above shows clearly that recourse to the electronically transmitted result for the purpose of collation will only arise where the hard copy of the result sheet does not exist. Given when the electronically transmitted result or the result on the IREV portal does not exist, the Commission will ask the copies handed over to the Nigeria Police or agents of political parties. The elaborate arrangement made by the first respondent for collation of results is to make sure that at every point of collation, there is a result either from the hard copy with INEC or the electronically transmitted copy or the IREV portal copy or a hard copy given to the Nigeria Police, and finally, or a copy given to political parties. I think I can confidently say, and in agreement with the respondents, that the unavailability of the election results on the IREV portal, for whatever reason, cannot be a ground upon which an election could be nullified, particularly as it is not the case of the appellants that the hard copies of the result sheets did not exist at any level of collation. My Lord, having failed to prove with or that there was any miscarriage of justice since of this started. Section 137 of the Electoral Act relied upon by the appellants for the failure to prove non-compliance in the manner we are used to provide. I quote, it shall not be necessary for a party who alleges non-compliance with the conduct of election to call oral evidence if President of the Federal Republic of Nigeria. In his argument, the learned senior counsel for the appellants urged this court to interpret the word "and" in section 134 2b of the Constitution conjunctively and not disjunctively, which will make it compulsory for a candidate to score a quarter or 25% of votes cast in the Federal Capital Territory before he can be President of the Federal Republic of Nigeria. The respondents argue otherwise. My noble lords, on pages 8234 to 8235 of Volume 10 of the Record of Appeal, the lower court made the following decision, and I quote, "As expressly stated in Section 299 of the Constitution for the purposes of fulfilling the requirements of Section 134 sub 2b of the Constitution for the return of a presidential candidate as duly elected, the Federal Capital Territory, Abuja, is to be treated as one of the states in the calculation of 2/3 of the states of the Federation, such that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to secure 25% of the votes cast in the Federal Capital Territory, Abuja, as the second respondent did." End of quote. To be very honest, I do not see anything wrong with the above decision. It is basic that one of the vital concerns of interpretation of statutes is that a court of record should be minded to make broad interpretation, or what is sometimes referred to as giving same a liberal approach. A court should give a holistic interpretation to a statute or the Constitution as required by law. Probably I may add that a court must give the Constitution or a statute a purposeful and people-oriented interpretation. What I'm trying to say is that in interpreting the Constitution, or any statute for that matter, a narrow and selfish approach, the duty of the court in interpreting statute should be in such a way that it serves the generality of the people and not for a select few. It is trite that the legislature does not intend creating injustice or an absurdity. Hence, the court must always adopt a construction or interpretation which will not reduce legislation to futility and absurdity. See Governor of Kwara State and Dada, citation supplied. Let me drive this matter home. The poster rendered by the learned senior counsel for the second respondent in their brief comes handy. Assuming that a candidate scores the highest number of votes in a presidential election and has 25% or 1/4 of votes in 30 out of 36 states and Abuja, but failed to secure 25% in the FCT, are we saying that he cannot be president? Is that what the Constitution intended? I don't think so. The court below made it very clear when it held that if the framers of the Constitution had wanted to make the scoring of 1/4 of votes cast in the Federal Capital Territory a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. End of quote. The above decision of the lower court is unassailable, and I have no difficulty in agreeing with it. I see no merit in this issue, and I resolve it against the appellants. Issue 3 calls on this court to interrogate the decision of the court below and answer the question whether the lower court was not in error to have expunged the witness statements on oath of appellant subpoenaed witnesses, namely PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, and the exhibits tendered by them on the ground that the witnesses' statements on oath were not filed along with the petition, and that Order 3, Rule 2 and 3 of the Federal High Court Civil Procedure Rules 2019 is not applicable in election matters. Learned Senior Counsel for the appellants falls the decision of the court below for relying on paragraph 4 of the first schedule to the Electoral Act, failure to apply the provision in Order 3, Rule 2 and 3 of the Federal High Court Civil Procedure Rules. He submitted that the interpretation given to paragraph 4.5b of the first schedule to the Electoral Act 2022 by the lower court in disallowing the testimonies of the appellant's subpoenaed witnesses will only lead to absurdity and prevent petitioners from compelling relevant evidence in possession of an adversary. In reply, the three senior counsel for the respondents in their various briefs submit in unison that the 21 days prescribed for filing the election petition cannot be extended under any guise, and that paragraph 4.5b of the first schedule to the Electoral Act cannot be enlarged to accommodate witnesses' statements on oath, which were not filed along with the petition. That having responded to the petition based on the facts and witnesses' statements front-loaded, their right to fair hearing will be trampled upon by allowing new evidence through those witnesses when they have no right to further reply. They urge the court to resolve this issue against the appellants. Let me reiterate the already tried position of the law that election petition is sui generis. That is to say, it is in a class of its own. As was held by this court in Abubakar and Yaradua, this is no longer a moot point. It is different from a common law civil action. In Kalu and Uzo, citation supplied, this court stated clearly that the Electoral Act of whatever version, particularly that of 2022, contains mandatory provisions. Thus, election petitions have certain peculiar features which make them sui generis. They stand on their own and bound by their rules under the law. It was further held that defects or irregularities which in other proceedings are not sufficient to affect the validity of a claim are not so in an election petition. A slight default in compliance with a procedural step could result in fatal consequences for the petition. It has to be noted that rules governing civil proceedings are not the same which govern election proceedings. And where the Electoral Act requires recourse to civil procedure rules, it must be made subject to the provisions of the Acts. My noble lords, a combined reading of Section 285, sub 5 of the Constitution of the Federal Republic of Nigeria as amended, and paragraph 4.5 of the first schedule to the Electoral Act 2022 shows that the time limit for the filing of written statement on oath of witnesses in election petition proceedings is 21 days from the date of declaration of results. As was pointed out by counsel for the respondents, due to the sui generis nature of the election proceedings, amendment to the petition or calling of additional witnesses will not be entertained after the statutory time limit for the filing of petition has expired. Thus, a petitioner cannot present his case in bits, otherwise the respondent's right to fair hearing will be breached. This was the position of this court in Oke and Mimiko, citation supplied. In his contributory judgment in the above case, Clara Ogumbiyi JS retired, made the following decision, and I quote, by paragraph 4, sub 1 and 5 of the first schedule to the Electoral Act, a composite analysis of the contents of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive. It is mandatory and conclusive. In other words, the provisions do not allow for additions, and hence the procedure adopted by the appellants in seeking for extension of time is nothing other than surreptitious attempt, which provides for extension of time. What is more, via paragraph 14.2 of the first schedule to the Electoral Act, the appellant by section 135 Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting application. Further still, and on a critical perusal of the application, Relief 2 seeks leave to call additional witnesses, to wit AEO. It is pertinent to restate that at the close of pleadings, parties had submitted the list of witnesses who were to testify together with their deposition. The idea, purpose, and intention of the application is suggestive of nothing more than a clear confirmation, seeking an order for an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions of section 285 sub 5 of the Constitution and section 134 of the Electoral Acts. End of quote. It has to be emphasized that the use of the word shall in paragraph 4.1 and 5 of the first schedule to the Electoral Act makes it mandatory and conclusive. The question may be asked, can a court extend time circumscribed by the Constitution for a party to do a thing he could not do before the expiration? The obvious answer is no. Such provisions like section 85 sub 5 of the Constitution are mandatory, and any exercise of discretion by the court is without jurisdiction and therefore a nullity. In APC and Marafa, citation supplied, this court held that application of time to call additional and file additional witnesses' statements after the prescribed period for presenting election petition are not permitted because election matters are time-bound, and by reason of being sui generis, the procedure in handling them are stricter than ordinary civil matters. See also Ararume and INEC citation supplied. Compel the impossibility, and that subpoenaed witnesses should be allowed to testify. But as was argued by the learned respondent, A.B. Mahmoud SN, subpoenas and the effect and purpose of 5 of the Constitution of the Federal Republic of Nigeria and paragraph 4.5 of the first schedule to the Electoral Act 2022. It is on this note that I hold that the decision of the court below to strike out the offending witness depositions cannot be faulted. I resolve this issue against the appellants. Issue 4 orbits around the evaluation of evidence of PW1, PW2, 3, 5, 7, and 22, who were the appellants' coalition agents at the court below. The appellants are aggrieved by the verdict of the court that witnesses were hearsay, thus inadmissible under the rule of evidence. For the purpose of clarity, I shall herein reproduce, albeit extensively, the observation of the court below, which led to the verdicts complained about as follows. Quote, the petitioners, it must be underlined, pleaded in paragraph 4 of the petition that the petitioners had agents in all the polling units, ward collation centers, local government collation centers, and state collation centers in all the states of the Federation and the Federal Capital Territory, as well as the national collation centers. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicate results in Form EC8A. The few agents called were state and national collation agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Kogi State. In paragraph 7, 8, and 11 of his statement, he deposed that from the analysis, he discovered various forms of non-compliance and corrupt practices such as suppression of votes, manipulation of the beavers machines, manipulation of accreditation, intimidation and harassment of voters, massive thumb printing of ballot papers, etc. This witness did not give particulars of these malpractices. There was no forensic report to support allegation of thumb printing at the polling units. In PDP and INEC citation supplied, this court, per Agim JCA, as it then was, held that it is only a polling unit agent or a person who was present at the polling unit during polls that can give admissible evidence of what transpired during the poll in that unit. See some cases cited there. In the instant case, PW1 was not a polling agent. He was a collation agent. When cross-examined, he said he would be wrong to say that he was present when all the ballot papers and boxes were manipulated, that he visited only 20 polling units out of the over 3,000 polling units in Kogi State. He admitted that his party had polling agents in all the polling units and that they were still alive. The PW2 is also a collation agent. His witness statement on oath is at pages 213 to 215 of the petition. His statement is similar to that of the PW1. He is Dr. Folarin Sunday Adekunle. He was the collation agent of the petitioner for Ogun State on the election day. Under cross-examination, he said he only visited 19 polling units out of the 5,040 of the polling units in Ogun State. PW3, PW4, 5, 6, 7, 8, 9, 10, 11 are all collation agents. The evidence of these witnesses centered around the events and the duties they carried out by the polling units agents of the petitioners. They agreed under cross-examination that the polling unit agents functioned very well in their units under our law. Specifically, in Section 43 of the Electoral Act 2022, polling agents are permitted to be appointed by political parties for each polling unit and collation center. The wisdom in this is for each of the political parties involved in an election to be represented by its own agents. The duties of an agent are to represent the interests of his or principal, having regard to the fact that no mortal can be in all the places at the same time. The law allows political parties to have their agents at all polling units and collation centers. It is therefore not anticipated by law for any political party to appoint an octopus agent with his tentacles in all the polling units and collation centers. This is humanly not practicable. When therefore evidence is required to prove what happened in any polling unit or collation center, it is only the agent who witnessed the anomaly or the malfeasance that can legally and credibly testify. It follows, therefore, that PW1, PW2, PW3, PW4, PW5, 6, 7, 8, 9, 10, 11, 19, 20, 22, who were state and national collation agents of the petitioners, can only testify of the events in their units or collation centers where they voted or acted as agents, and not all over the states of the Federation. The polling agents, as presented in this petition, it must be noted, are not shown to be experts. The issue of their analyzing results of the election at the ward, local government, state, and national level without calling polling unit agents who witness the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify as of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. It follows that the evidence of the coalition agents in this instant case, who are PW1, 2, 5, and 7, relating to suppression of votes, multiple thumb printing of ballot papers, entering of wrong scores results, disruption of voting, are inadmissible hearsay and are hereby discounted as end of quote. Without reservation, I endorse the above statement of the lower court, which is consistent with plethora of decided cases on the subject. Buhari and Obasanjo, Ladoja and Jimobi, and others cited. From the evidence on record, it is indisputable that PW1, 2, 3, 5, and 7, who were the appellant state coalition agents and national coalition agents, were not present in all the polling units, which results they have disputed, which means that their evidence in respect of all the polling units, other than the ones that they were present, were clearly hearsay. They were most likely informed by the polling unit agents who were alive but failed to testify. I must say that the above statement of the lower court had nothing to do with the court's failure to ascribe probative value to documents put in evidence pursuant to Section 137 of the Electoral Act 2022 and paragraph 46(4) of the first schedule to the Electoral Act, as vehemently submitted by the appellants. Indeed, the point is instructive in view of the fact that the court had earlier on page 8,102 of the record rejected and overruled the third respondent's preliminary objection, seeking that documents tendered by the appellant be expunged for being dumped on the court. The finding of the lower court in discountenancing the evidence, analysis of PW1, 2, 3, 5, and 7, same being based on hearsay, cannot be faulted. More so, the appellants have not presented any argument to warrant the interference of this court with the finding of the lower court. The issue, again, is resolved against the appellants. Issue number 5 is whether the lower court was not in error in striking out several paragraphs of the petition and the replies of the appellants on the ground of vagueness and lack of specificity and for being new issues, mere denials, or being repetitions. Well, this issue relates to the ruling of the court below on the first respondent's preliminary objection, seeking an order of court striking out 31 paragraphs of the petition on the ground that they were vague, generic, imprecise, and lacking in specificity to elicit reply from it, and contrary to paragraph 4.1 of the first schedule to the Electoral Act 2022. The court, after scrutinizing each of those paragraphs in a well-considered ruling, struck out 10 paragraphs, namely 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 for being vague, imprecise, and lacking in particulars. For the purpose of clarity, the court held on page 8025 to 8026 of the record as follows. The sum total of all the foregoing is that while paragraph 129 and 133 of the petition are liable to be struck out for non-joinder of necessary parties, to which Messrs. Adejo, and Governor Yahya Bello of Kogi State, accused in the petition of committing electoral malpractices, paragraph 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack of particulars, and so fall short of the requirements of paragraph 4 sub 1b of the first schedule to the Electoral Act 2022. They are therefore all others struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 110, 111, 112, 113, 14, 115, 116, 118, 119, 120, 122, 125, 130, 134, 138, 139, 140, 141, 42, 145, on the other hand, are in order and properly pleaded, end of quote. Picked by the above ruling, the appellants now seek the interference of this court on the ground that their averments were sufficiently detailed. They also question the decision of the court, striking out their replies to the respondents' replies to the petition. For instance, as touching on the disqualification of the second respondent from contesting election for the office of president, which particulars were supplied in the appellant's reply. It is instructive to note that in paragraph 146 of the petition, the appellants simply averred that, quote, the second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, end of quote. They did not supply the particulars of the threshold, which they perceived disqualified the second respondent from contesting the election, as enumerated in section 137 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Howbeit, in their reply, the appellant ruled out monstrous particulars of disqualification by reason of dual citizenship, allegation of being an ex-convict in a USA district court, having forfeited to the USA the sum of $460,000 in a drug-related case, Note that these particulars referred to as further details were brought in by the appellants at the time when the respondents had lost their right of reply, which in essence offends the cardinal principle of fair hearing expressed in the Latin maxim audi alteram partem, meaning let the other side be heard as well. Paragraph 4 sub 1 of the first schedule to the Electoral Act 2022 provides that an election petition shall A, specify the parties interested in the petition, in the election petition, B, specify the right of the petitioner to present the election petition, 3, state the holding of the election, the scores of the candidates, and the person returned as the winner of the election, and 4, state clearly the facts of the petition and the ground or grounds on which the petition is based and the relief sought by the petitioner. It is clear beyond a peradventure that the requirements of the law is as provided above, is that the petition must demonstrate with specificity the complaints of the petitioner and the relief sought from the court. It gives no room for vagueness and imprecision. This is in line with the rule of pleading, that where an averment is not supported by evidence, the averment is deemed abandoned. For, in keeping with the audi alteram partem rule, to prevent surprise or ambush on the defendant, it is the plaintiff's claim that will enable him to file his defense. See Wayne West Africa Limited and Ekonife citation supplied, Akonde and Adisa and another citation supplied, PDP and INEC citation supplied. It follows, therefore, that a petition must be detailed and comprehensive on material facts depending on the relief sought, and not evasive or vague, so as to elicit a response from the respondents. Indeed, By the provision of paragraph 16, sub 1A of the first schedule to the Electoral Act 2022, the Act frowns at the introduction of new facts, grounds, or prayers tending to amend or add to the averments of the petition in the petitioner's reply. In fact, a petitioner is only required to file a reply in answer to new issues or facts which may be raised in the respondent's reply, which were not dealt with in the petition. This means that where there are no new issues or facts raised in the respondent's reply, there would be no need for the petitioner's reply. See Oni and Oyebanji, citation supplied. I have critically considered the arguments of parties contained in their respective briefs of argument vis-a-vis the record of appeal. The affected paragraphs of the petition relates to allegation of wrongful cancellation of polling unit results in various local governments in Sokoto State without particulars, manipulation of results in unspecified polling units in some local government areas of Kogi State, wrong results entered for the appellants in unspecified polling units in Borno State, criminal allegations against Honorable Adejo and Governor Yaya Bello without joining them as parties to the petition, open-ended allegation of disqualification against the second respondent, and tying critical allegations of corrupt practices in the election to a statistician report prepared by one Samuel Odutan, that's PW 21, without serving the said report on the respondents along with the petition to enable them respond thereto. I am unable to agree with the appellant's argument that the lower court was wrong to have struck out the affected paragraphs for disclosing no particulars, together with some replies in the appellant's reply brief, which sought to bring in new evidence through the back door. I uphold the decision of the lower court, striking out the affected paragraphs and replies of the appellants for being vague, imprecise, lacking in particulars, and seeking to ambush the respondent via the petitioner's replies. The ruling of the lower court is unassailable, and this court will not interfere. This issue, again, is resolved against the petitioners. Issue 6 is whether the lower court was not in error in its evaluation of the evidence of the appellant witnesses on the burden of proof and clear admission against interest made by the first respondent. This issue turns on the averment of the first respondent in paragraph 8 of his reply to the appellant's petition that the appellants in this case won the contested election in 21 states out of the 36 states of the Federation, namely Adamawa, Akwa Ibom, Bauchi, Bayelsa, Borno, Delta, Ekiti, Gombe, Jigawa, Kaduna, Katsina, Kebbi, Kogi, Kwara, Nasarawa, Niger, Osun, Sokoto, Taraba, Yobe, and Zamfara states. The appellants contend that such averment is tantamount to admission against interest by the first respondent. They therefore question the declarations to return of the second respondent as the winner of the said election. On its part, the first respondent contended that its said admission is of no consequence, having regard to the fact that the appellant scored 6,984,520 votes, as against the second respondents who scored 8,794,726 votes. That in determining the winner or loser in an election to the office of president, the number of states won by a candidate merit any consideration except in the context of geographical spread and ensuring compliance with the constitutional requirements. In its evaluation of evidence on the issue, the court below on page 8238 of the record had this to say, quote, "The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So, where the complaint in an election petition is that the candidate returned did not poll majority of highest votes in the election to be returned, as contended here by the petitioners, not only must the figures disputed be pleaded, the figures of votes the petitioner perceives as correct figures of the election ought to and must be pleaded. The court went further to hold on page 2854 of the record that, quote, Section 134 sub 2 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her in the absence of any rival or alternative result placed before this court by the petitioners. That the second respondent, who scored 8,794,726 votes as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election, end of quote. The above statements, qua holding of the court, represent the correct position of the law, and I wholly endorse same. I have earlier in this judgment resolved the issue of electronic transmission of results, which is the main thrust of the appellant's contention in this appeal. I shall not revisit the point under this issue. On the contention that the first respondent's averment that the appellant won 21 states out of 36 states of the Federation, thus constituting an admission against interest, the position of the law is well settled, having regard to who can be declared winner of a presidential election in Nigeria. Section 134, sub 2 of the 1999 Constitution makes it explicit that, quote, a candidate for an election to the office of president shall be deemed to have been duly elected where, there being more than two candidates of the election, A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja, end of quote. In this appeal, the issue before us is not who among the candidates won in the majority of the states of the Federation, which is debatable, but who scored the highest number of votes at the election. I have strenuously combed through the respective briefs of the parties vis-à-vis the record of appeal. I am unable to find any alternative figure put forward by the appellants as their rightful votes scored in the election, other than the scores presented by the first respondent, INEC, showing that the second respondent scored the highest number of votes. It is presumed correct. In the case of Abubakar and Yaradua, citations supplied, this court held that, and I quote, election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption, end of quote. See also CPC and INEC, Buhari and Obasanjo, Hashidu and Goje, all citations supplied. Following from the above, it is clear that the appellants, having not put forward their perceived rightful score to rebut the result put forward by the INEC, the law presumes the first respondent's version as correct. It would not matter whether the appellant can prove having won more states or if the first respondent admits that much. The figures before us shows that The second respondent won the highest number of votes and was accordingly returned elected. From whence, therefore, would we manufacture evidence to support the appellant's claim that they scored the majority of lawful votes cast at the election, or that there was non-compliance with the Electoral Act, which affected the credibility of the election? Nowhere, definitely not from the evidence on the record. And that is why this issue is resolved against the appellants. Finally, let me say a few words concerning issue number 7, which is whether the lower court was right in its use of disparaging words against the appellant in its judgment, evincing hostility and bias against the appellants, thereby violating their right to fair hearing and occasioning grave miscarriage of justice. I have read the judgment of the court below, and I've seen the context which those words were used, and it is my view that they were not meant to disparage the appellants or their counsel. As judges, we are trained to be temperate in our use of words, and we shall continue to do so. Litigants are advised to trust the court whenever their matters are before it. It is very unbecoming these days that while a matter is pending in court, litigants engage in press conferences, analyzing the case, reaching conclusions. Based on this, some of their followers send threatening messages to judges and justices. Matters in court are said to be sub judice, and as such, parties, and probably their counsel, should refrain from media trial and media judgments. I need not say more on this. A word is enough for the wise. This issue has nothing positive to offer the appellants. On the whole, having resolved all the issues against the appellants, it is my view that there is no merit in this appeal, and it is hereby dismissed. The judgment of the court below, delivered on the 6th of September 2023, affirming the election of the second respondent as the duly elected President of the Federal Republic of Nigeria, is hereby affirmed. I shall make no order as to costs. My learned brother on my right will deliver his judgment.
Well, my lords, learned senior counsel and all other counsel, this time around it will not be a 12-hour judgment. So, my Lord, Honorable Justice Okoro has said it all, but we must agree. So, having had a preview of the judgment of my learned brother, John Ian Okoro, JSC, availed me with a copy of the said judgment just delivered in SC/CV/935/2023. Atiku Abubakar and the Independent National Electoral Commission and others. I completely agree with the critical analysis of both the oral and documentary evidence presented before us in this appeal. Therefore, I agree with my learned brother that the motion of the appellants filed on the 6th of October 2023 for leave to the appellants to adduce fresh or additional evidence is devoid of any merit. I also dismiss the same. On the main appeal, my learned brother resolved all the issues, the 7 issues against the appellant. I therefore agree with him that the issues in the main appeal are devoid of merit and the appeal is accordingly dismissed. And I also did not make any order as to cause, but affirmed the judgment of the lower court, declaring the second respondent, Bola Ahmed Tinubu, as the duly elected President of the Federal Republic of Nigeria in the election of the 25th of February, 2023. Thank you.
My learned brother to my immediate left would deliver his judgment.
The lead judgment just delivered by my learned brother Okoro Jesse has comprehensively presented all the points I made and the views I expressed at the conference of the Honorable Justices of this panel over the appeal. He has very proficiently presented all the views which I express in respect of all the issues, both the motion for leave to adduce or produce fresh or additional evidence, as well as the first respondent's motion to strike out some grounds, and the main appeal itself. But I would like to say that the point raised by the learned senior counsel for the appellant, Chief Chris Uche, particularly in respect of the application of Section 285(6) of the Constitution, appears to me interesting, attractive, but when taken along with the relevant provisions of the Constitution, as well as the Electoral Act 2022, it with respect to Chief Uche Ezean spacious. As demonstrated in the lead judgment, the provisions of Section 285(6), even if the Court of Appeal is not specifically mentioned in that section, the provisions of Section 285(6) is applicable and apply to all proceedings in respect of all petitions, whether before tribunals or the Court of Appeal sitting as a court of first instance trying a petition named Presidential Election Petition, for which it was conferred or vested with the original exclusive jurisdiction to try and entertain under Section 239(1)(a) of the Constitution. So I completely agree. This is an interesting point, like I said, because this is the first time it is coming up, and it is good that this court will make a firm pronouncement in order to avoid further or future arguments in respect of this particular issue. In addition, the issue of a candidate scoring 1/4 of votes in the FCT has also been settled by this court before now. And it is in line with that decision and position that the lead judgment had affirmed that the FCT is not elevated to a higher pedestal than any of the states of the Federation. It is, for the purposes of the presidential election, one of the states for which a candidate is required to obtain at least 1/4 of the votes in 2/3 of each of the states. So I totally agree with the lead judgment that this court lacks the requisite jurisdiction to entertain the application for leave to produce fresh or additional evidence, and that this appeal is also lacking in merit and deserves to be dismissed. I also dismiss the appeal, and that would be my judgment in this appeal. I abide by the consequential orders made in the lead judgment on cost to be borne by the parties for the prosecution of this appeal.
My little brother, Salawa, will deliver his judgment.
My learned brother, the Honorable Justice Okoro Jesse, has accorded me the opportunity of a preview of the judgment that he has just delivered. I must say that I have read that judgment, and I'm very much content and appreciative of the far-reaching, erudite reasoning and conclusion that have so far been reached in the lead judgment. I concur with the highest sense of responsibility with the reasoning and conclusion reached therein. With particular regard to the interlocutory application, thereby urging upon this court to grant leave to the appellants to procure and transmit and adduce fresh or additional evidence at this crucial point in time of the appeal. I concur most assiduously with the conclusion that has been reached in the judgment of my learned brother that such an application is grossly unmeritorious, thus ought to be dismissed, and same is accordingly hereby dismissed by me. And as for the substantive appeal itself, which has been predicated upon a total of 7 issues, I agree entirely with the reasoning eruditely expressed by my learned brother that each of the 7 issues that has been canvassed and argued by the appellant are grossly unmeritorious, thus ought to be resolved against them. Without much ado, I hereby accordingly dismiss the appeal for being grossly unmeritorious. As usual, it is not the time for us to read elaborative judgments. Just like my learned brother said, 12 hours. We're not going to do that because learned counsel representing the respective parties in this appeal will have every opportunity to be served with the complete judgments of each and every justice of this panel in due course. Because constitutionally, we have a total of 7 days within which judgments must be served on the respective learned counsel that appeal. Thank you very much.
My Lord Jaro, read your judgment.
Thank you. Well, I have had the privilege of reading before now the lead judgment delivered by my learned brother, John Ian Okoro, JSC. His Lordship has ably considered and resolved all the issues in contention in the appeal, as well as the application. I agree with the reasoning and conclusion reached therein to the effect that the appeal is bereft of merit and deserves a dismissal. The application, too, is not meritorious. Accordingly, I dismiss the application and the appeal. That is my position.
My Lord Abubakar.
I thank my Lord the Presiding Justice, Honorable Justice John Ian Okoro, for granting me the privilege to read in draft the lucid and illuminating leading judgment just delivered in this appeal. I start with the application. The application seeking to adduce additional evidence or fresh evidence, I also find it lacking in merit. The application is frivolous and vexatious. It deserves to be dismissed, and it is hereby dismissed. Now, coming to the substantive appeal, I find no merit in the substantive appeal. It is also dismissed. On the whole, therefore, the appeal is dismissed and the judgment of the lower court is affirmed. Parties in this appeal shall bear their respective costs.
Yes, Iroko. Agim, JSC.
With the kind permission of the learned presiding justice, let me also express my view. I had a preview of the judgment delivered by my learned brother, Lord Justice John Inya Okoro, JSCFR. I completely agree with the reasoning, conclusions, decisions, and others therein. And I must remark that it is bristling with commendable erudition. Let me, however, say maybe one or two things, since we will have opportunity, you will have opportunity to have our views, that the deposition is, for this additional reason, inadmissible. So if a document is inadmissible, you cannot ask that you should be allowed to bring it in as fresh evidence. A reading of the deposition exposes that it is not authenticated by the seal of the authority before whom it was issued. A deposition from another country to be used in Nigeria should prima facie bear features of authentication, such as the official seal of the court where it is sworn, if it is the court, or if it is before a notary public, his seal or signature, or if sworn before a person legally authorized to take the seal, or if sworn in the Nigerian Embassy, High Commission, or Consulate in that country, the signature of the officer authorized to do so, and the seal of the Embassy, High Commission, or Consulate. Such authentication is an assurance of the origin and authenticity of the foreign disposition. In our present case, the certified shorthand reporter, before whom the deposition was made, did not authenticate the deposition with her seal. She merely signed her certificate of reporter bearing her name and number, page 126 of Exhibit C. Being a deposition from another country, it cannot be used in Nigeria without authentication. The authentication of the oath administration is mandatory. I have wondered why the deposition said to be made pursuant to the 3rd October 2023 order of the United States District Court for the Northern District of Illinois in case number 23 CV 05099 for use in a foreign country was not made before the court in the said proceedings. And if made elsewhere in the law office of the first appellant's attorney, why was it not filed in the above-mentioned court because of the peculiar circumstances of this case and adopted as a deposition ordered to be made by the court so that it can form part of the record of that court to enable the court issue it as part of its record, also authenticate it with the seal of the court and the signature of the relevant officer of the court. Page 1 of the deposition is headed in the United States District Court for the Northern District of Illinois in reapplication of Atiku for an order directing discovery from Chicago State University pursuant to 28 U.S.C. 1782 number 28 CV 05099. This gives the impression it is a process of the District Court or that the deposition, though made outside the precincts of that court in a private law office, is part of the proceedings in case number 23 CV 05099 if it is indeed a process of the said district court or forms part of the proceedings in case number 23 CV 05099 before it, then it ought to have been authenticated by the official seal of the court and the signature of the relevant officer certifying it as a true copy of the part of the record of the court in case number 23 CV 05099. Without such authentication, a deposition cannot be used in the Nigerian court as part of the proceedings or in the said U.S. District Court. And I've continued to wonder why the appellant did not use the advantage of the order of the district court that the college produced documents and a deposition concerning those certificates. Why they didn't use that advantage to secure a letter from the college under its letterhead, seal, and signature, disclaiming the certificate presented by the second respondent to INEC as not one issued by the college. That was not done. Instead, they resorted to this deposition, which has no features of authentication, thereby rendering it spurious and inadmissible. I agree with the able manner the lead judgment has dealt with it. I agree totally with all the reasons given in that decision as to why such a application should be refused, and it emphasizes one point. It was obvious to all, including those who brought it, that it was going nowhere. Then the question is, why was it brought? And I agree with my Lord when he described it as a vexatious process. I dismiss the application too. I go to the appeal. I agree completely with the lead judgment. I cannot say it better than that. It was a real brilliant expose on all the issues raised. Let me also join my Lord Garba to talk about a question of Abuja and 1/4 of the votes there, that the candidate must win. They view that the provision of the Constitution should be applied in such a way that the votes in Abuja must be won. 1/4 of the votes must be won by a candidate before he can secure victory in election. To me, violates a fundamental principle of constitutional interpretation, that it must be interpreted to protect the spirit of the Constitution. And if you look at our Constitution, it promotes egalitarianism, equality. So it must be applied in such a way as to protect the equality of the votes in all the entities, and not otherwise. I will expand on that in my judgment. So I do not agree with the interpretation placed upon it. Attractive as it may be, but we must bear in mind that there's no jurisdiction in the world where a constitution is read in isolated patches and given meaning that should have, very narrow meaning that should appeal to certain sentiments. No, you apply it as a whole, reading it completely together, so that you rely on one part to get a meaning in another part, that the words can truly support the wordings used in that provision. That is how to read a constitution. Yet remembering that it is dealing with a dynamic system, a human society. For these reasons, I also dismiss the appeal. I also agree that the parties should bear their costs. Thank you very much.
Thank you, my lord. We are now left with the next appeal. I call the next one.
SCCV 937-2023. Mr. Peter Gregory Obi, Labour Party, Appellants, Independent National Electoral Commission, INEC, Senator Bola Ahmed Tinubu, Senator Shetima Kashim, All Progressives Congress, APC respondents.
Appearances.
The Lordship, my name is P.I.N. Ikweto. My Lords, unfortunately, we have a type list of counsel, and by the time my colleagues brought it to the registry, they were told it was late. If Your Lordship allow me, can I submit that list?
Please, sir, submit it.
Thank you, my Lord, sir. And my Lords, with respect...
Judgment day, we don't go late to court.
I was here before, I was here by 8 o'clock, sir.
So that you won't be late when God will be giving judgment.
Oh, my Lord, on the day of my own judgment before the Lord, I will be there alone. So I will never be late there.
So...
And I'm sure you will accept me when I get there, sir.
God will accept you.
I'm sure you will.
I pray it should be so.
Amen, sir. My Lord, I want to say that my name is P.I.N. Ikweto, and Your Lordship, with respect, we have, in line with Your Lordship...
I think we should start calling you Saint Ikweto.
My Lord, I cannot be while still on earth. Yes, sir.
Until you die.
While still on earth, I cannot be. I'm a sinner.
Let's find a place and discuss that.
Your Lordship, please. My Lord, I don't know where we can discuss that, sir. My Lord, we've taken the liberty to tick the names of my colleagues who are with me.
Azinge.
Number 3, Dr. Mrs. Valerie Janet Azinge, SN. Number 4, my Lords, Alex Ejesieme, SAN.
Azinge.
Yes, sir. Azinge is number 3, sir.
Yes.
Number 4, my Lord, is Alex Ejesieme, SAN.
Where is Azinge?
My Lord, Azinge is just beside me here. She's been here all morning with me.
Azinge used to be black. I don't know why she's white today.
No, she's always been fair complexion. Always. Yes, sir. The husband is dark complexion.
Okay, it's the husband that is dark.
As a Lordship, please. Yes, sir. But she's been fair complexion all along.
It's okay. You're welcome.
Yes, my Lord.
Leonard SN Ikweto, did you say Valerie is number 3?
My Lord, on the list, she's number 3.
But she's number 2.
She's number 2, yes, sir. Yes, sir. I just want to make it easier for my Lord, sir. The next, my Lord, is Mr. Alex Ejesieme, SAN.
Yes. Chike.
My Lord, as a Chike A.O.B. Esquire.
Yes.
And my Lord, lastly, and in compliance with my Lord's directives,
Ejiofor
Onwaso Esquire. Your Lordship, the appearance with due respect is for the appellant in this appeal.
Yes.
Please, my lords. I am Sir Stephen Adehi. I am number 2 on the list.
Where is your list?
We submitted a list this morning, my lord.
Stephen
Adehi, my lord. Sir Stephen Adehi.
Leave that thing. Adehi.
Yes, my lord.
Yes.
I appear with my learned friends of the inner bar.
Yes, yes.
Al-Hassan A. Umar, S.A.N., is number 4 on the list.
Umar.
Yes, my lord.
Yes.
And number 7 is Wendy Kuku, Esquire, my lord.
Yes. Yes.
Number 8, Jamiu Aguru, Esquire.
Where is Jamiu Aguru?
And finally, number 10, Z.U. Obansa, Esquire. Our appearance, my lord, is for the first respondent. May my lords be pleased.
Yeah, for the... Yes. Tell those guys, tell them that this thing can amount to contempt of court, so they should be careful.
My lord, the last person on our list, my lord, is actually number 9, Amira Hamisu, not Obansa. Number 9.
Who?
Amira Hamisu, Esquire. Yes, my lord. Not number 10, my lord. Thank you very much, my lords.
1, 2, 3. Amira. Hamisu. Yes.
If it pleases my noble lords, my name is Akintola Makinde, and I appear with my colleague, Okpe Moritala. Your lordships, we submitted a typewritten list in the morning. Very respectfully, our appearance is for the 2nd and 3rd respondents. We are very grateful, sir. Okpe Moritala, my lord, is number 2 on the list here.
Yes.
We are very grateful, sir.
Yes. Yes.
Respondent.
Yes.
Appearing with me, I'm learned friends. My lord, I'm sorry, the next name is not on the printed list which we submitted.
Let me, okay, here.
Professor Abdul Karim Kana. And Abdul Wahab Abayomi. We all respectfully appear for the 4th respondent. I'm much obliged, my lord.
For the 4th respondent.
Respectfully, my lord.
Yes, well, in this appeal, we have, during conference, noticed that issues number 1, 2, 3, 5, 6, and 7 in this appeal have been dealt with in Atiku's appeal. It is the decision of this court that this issue shall abide the outcome of the issues as resolved in Atiku's appeal, mutatis mutandis. As for issue number 4, which has to do with double nomination, which was not in Atiku's appeal, it is the view of this court that this issue, having been dealt with by this court in S6 to CB to 501 to 23, which judgment was delivered on the 26th of May 2023, this court cannot allow the matter to be relitigated in this very court. There must be an end to litigation. For us to sit down now and talk about when this man resigned or did not resign, when they did a fresh conference or fresh primaries to replace him, which we have done before. We are not going to do it again. This matter ought not to have come here. When the matter was pending at the trial court, this court delivered that judgment. If you read the judgment of the lower court, they mentioned it, that Supreme Court has settled this matter. And that should have been the end. You now bring this issue of double nomination for us to sit on it and write another judgment. This is not how it should be. This appeal lacks merit and is hereby dismissed. My Lord, to my right, Abaji.
I agree with my learned brother, Justice John Ian Okoro, that this appeal, number SCCV 937, 2023, Mr. Peter Gregory Obi and the Independent National Electoral Commission lacks merit, and it is also dismissed by me.
My Lord, Garba Jesse.
I also totally agree with the lead judgment that this appeal substantially canvass the same issues with the appeal number 935, 2023, which this court has very comprehensively dealt with. And there is no need for us to repeat ourselves because the issues are the same. The only issue that's different, like pointed out by my learned brother, the PJ, is that about double nomination, which you have settled. And we do not intend to reopen it again in this appeal. On the whole, I also join the lead judgment to dismiss this appeal for lacking in merit.
My Lord Salawa.
Having had the privilege before now of reading in draft the judgment prepared and delivered by my learned brother Okoro JC, I cannot but concur with the far-reaching reasoning and the conclusion that has been postulated in the judgment to the effect that the instant appeal lacks merit, thus ought to be dismissed by this court. Having associated myself with that reasoning and the conclusion, I have no hesitation whatsoever in dismissing the appeal. Appeal dismissed.
My Lord Jauro.
Well, I had the advantage of reading in draft copy of the lead judgment just delivered by my learned brother John Ian Okoro JSC. I entirely agree with the reasoning and conclusion contained therein that the appeal is devoid of merit and it ought to be dismissed. Consequently, I join my brother in dismissing the appeal.
My Lord Abubakar JSC.
I also had the advantage of reading in draft the judgment of my learned brother Ian Okoro JSC, and I am of the view that the appellants have nothing useful to urge this court. The appeal lacks merit, and it is hereby dismissed by me.
My Lord Agim JSC.
I had a preview of the judgment delivered by my learned brother, Lord Justice John Iyan Okoro. I completely agree that this appeal lacks merit and it should be dismissed. I hereby dismiss it.
Thank you all for listening. The two appeals, I think we have concluded our job today. What remains is for us to go and rest. Thank you very much. We shall rise.
Ella.
All litigation must come to an end. They addressed all the issues, about 7 of them, and those issues were, and the judgments on each of the issues were clearly unassailable as far as I'm concerned. So for me now is the time for us all, every Nigerian, particularly the president, to roll up his sleeves and continue with governance. This has been a distraction. The litigants exercise their rights to go to court, but that has come to an end now. We now have to all come together as one country, one people, and move ahead and take this country where it rightfully should be. We're happy. We're excited.
So coming together, does
yes.
that mean that you'll be extending a hand to the PDP and the Labour Party? Although the APM's appeal was dismissed, but would the president be extending a hand of friendship or sportsmanship to the other political parties?
Well, listen, we shouldn't take these things personal, right? If you listen carefully to the judgment was very sound by any objective, right-thinking person, supported with facts, with cases, with statute. The president, if you know him very well, is a Democrat. It's not now that he's extending his hands of fellowship. He's always done that. He will continue to do that, and will continue to do so on his behalf. Governance is about everybody. It's not about a party. It's not about an individual. And if we do not come together now, then we'll have ourselves to blame. Opposition is not, you don't oppose for the sake of opposition. Elections are over, litigation is over. All litigation must come to an end. Now is the time for governance. Distractions over. So yes, Mr. President, the APC, and all rightful thinking members of the society must come together, no matter what party you belong to address the issue of governance.
Thank you very much.
Thank you very much.
Sir. Excellent.
Okay. Well, I want to first give all the glory to Almighty God for this judgment. It is indeed another day that the Lord has made. We're glad that this puts an end to all litigation and a closure to all the speculations and all that. Mr. President, in his magnanimity, I'm sure will now again reach out to all to join hands with him in his renewed hope agenda. APC was his platform, but the Nigerian state is where he's president of. So this is not just a victory for our party APC, it's a victory for the country. And we want to salute the judiciary, starting from the Supreme Court, the Appeal Court. Their judgment was very detailed, it was very meticulous. It laid the foundation for the Supreme Court judgment. I want to salute the judges of the Supreme Court as well. It was straight to the point. And I believe that this judgment would be seen worldwide as that which is in line with global best practices in law. I want to salute them again because, they are the bastion of hope for everybody, including the common man. And this is a victory for democracy. Opposition can now go and rest. If they indeed mean well for this country, I expect that after today, they will call President Bola Ahmed Tinubu. They will congratulate him. They will now sit down and fashion out how to join hands with him in ensuring that indeed we achieve and continue to achieve our pride of place in the Committee of States across the length and breadth of the world. Once again, I congratulate President Bola Ahmed Tinubu for this victory, and I congratulate APC, I congratulate Nigeria. Thank you very much for having me. Thank you.
Yes, just one question.
Okay, what is it? Yes.
Yes. The court today said that the FCT has no special status. As the minister of the FCT, what do you have to tell me?
Maybe you don't understand when he said FCT has no special status. What he said that in terms of calculating or having the status quo, you must not win FCT before you are declared president of the Federal Republic of Nigeria. That FCT is like another state. So that you don't need to say, oh, if you don't win FCT, therefore you cannot be declared. That's what he said.
So you must please start with the APC crew. Can we please say that you have moved to the APC?
I didn't come with APC crew. And in the court here, in the court here, I don't know where they said APC and PDP. I came here as somebody who's interested, as somebody who wants the country to move forward. So I congratulate Mr. President, and I think that this has come to the end. No more speculation. So Mr. President can focus and do what he's supposed to do for Nigerians. Thank you.
Thank you.
I just want to Chairman.
Election litigation and the delay it seems to constitute election litigation and the delay seems to constitute distraction. Will you be moving for some form of amendments?
Well, you see,
what is your advice to your opponents?
well, you see, this is a developing democracy in a developing nation, so you expect such distractions to occur. But I believe we fine-tune our laws, especially electoral laws, and and we believe we shall come to the mature stage that we are expecting. Pertaining to acceptance of this verdict, I urge our colleagues, politicians, to accept it in good faith. And also I have to use this opportunity to congratulate politicians, to congratulate the leaders of the opposition political parties, because it is better for them to resort to judiciary, which they have done so, rather than taking, arms against against each other.
Yeah.
So we have to congratulate our politicians for resorting to judiciary, and the judiciary has done well. It means that democracy is getting matured in Nigeria, and we are happy with that.
Many thanks, sir. Thank you.
And that has been the proceedings from the Supreme Court here in Abuja. Shola Shoyele reporting for Channels Television News.